So thank you very much. This is one of my favorite gigs that I do every year, largely because when I pull in, there's a parking spot that says labeled, nobody treats you like the Rutherford Institute. So my topic of my talk today is women at the Supreme Court and how they're changing it, because this has really been an extraordinary thing, having 3 women at the court. And this is my 12th year covering the U.S. Supreme Court. And it's really remarkable, the difference it's made. So I'm going to talk about that, and I'm going to try, I've got a 1 p.m. flight that I've got to make. So I'm going to try to kind of be out the door at 11:30, so I'm going to leave tons of time to answer questions about the court. And hopefully I'm going to also try to leave, this is maybe too aspirational, but I'm going to try to leave a few minutes to talk about the free speech cases at the court this year, because this has actually been a relatively boring year at the Supreme Court, but the 3 speech cases have been really remarkably interesting. So I thought I'd try to make a little space to talk about that, but let's see how we go. So I just want to start by saying, you know, when you talk about women at the Supreme Court and their impact on American jurisprudence at the Supreme Court, the first really important caveat has to be that this is a very limited case study. We're talking about 4 individuals over the span of only 30 years. And in the case of, you know, the sweep of history, that means that you're talking about not a lot of data. In the grand scheme of things, that's statistically insignificant, but I think there's some really interesting trends and themes and questions that it raises about what it means to finally have 3 women at the court. And so I'm going to talk today about questions like, does it matter that women are at the court? Is there a certain kind of women's jurisprudence that has emerged at the court? Do women judge differently than men? Do they judge certain kinds of cases differently than men? Are we entitled to have 5 women on the Supreme Court the way we do on the Canadian Supreme Court because women represent half the country? Does it matter? These are the questions that I want to raise, and I want to be really clear that the studies on this are terrible. The actual data out there that sort of tries to answer these questions is quite recent and quite bad. So really we're going to opine here, we'll have a conversation, but I can't back it up with fantastic data. I wish I could. One of you someday will write the definitive paper on that and send it to me. And the only other sort of precatory observation I want to make on this topic is simply that the last time this speech was given, it was Sonia Sotomayor at Berkeley in 2001, and she gave her unfortunate Wise Latina speech, where she tried to answer these questions about whether women think differently than men, whether it matters that women are equally or fairly represented on the bench. And you may recall what happened to her for that. So good thing I am not planning on being on the U.S. Supreme Court, but I think it's just, I think, a testament to how fraught this conversation is, that you can't even raise these questions without imperiling your own chance of being confirmed down the road, because you come out looking like the kinds of person who is biased or unfair. So I just want to really bracket my remarks by saying I think it's incredibly interesting that these are the questions that Sotomayor was trying to probe when she said the unfortunate sentence, perhaps a wise Latina woman would come.
What did you say? I've forgotten.
I will tell you. I'm going to tell you. I'm going to directly quote her in a minute. But I think that the substance of what she said at Berkeley was, in a certain class of cases involving some litigants, it is possible that a wise Latina woman would come to a better conclusion than another judge. That was, and you may remember the confirmation hearings where we talked about that for 5 days. Now I'm going to add that this is my 3rd time doing this talk. It's my first time where I'm not jetting out to do a confirmation hearing the following week. Knock wood, unless someone quits in the next week. And certainly I want to also leave space to ask questions about retirements and the composition of the court. I think there's certainly, this is a very old court, and there's certainly rumors of retirements this term, but I don't think there will be one. All right, so I'm going to posit this as a sort of a Shakespeare play in 5 acts. The effect of women on the court, and sort of give to you 5 different eras of women at the Supreme Court, and we'll think of it like high drama. And the first era I want to talk about, I want to call the different voice era. And that, you may recall, The first person tapped for the U.S. Supreme Court was Sandra Day O'Connor in 1981. It was noteworthy for several reasons, not the least of which was that Ronald Reagan promised expressly to put a woman on the court. So he ran on that. He said he would put the first woman on the court, and he did. This was not a subtext. This was not a bait and switch. She knew right from the beginning that she was a kind of obscure judge from Arizona who had a kind of interesting history as a state legislator, but that by no means was she in the pantheon of the sort of Harlem Globetrotters who are usually tapped for the Supreme Court. One of the things that's funny about O'Connor is she thinks that's hilarious. She's in no way bothered or embarrassed by the fact that she was explicitly tapped to be the first woman on the court. And when Justice Scalia in conference used to tease her about it, she would just laugh and say, well, of course, haha, lucky me. So I just want to think about that in contrast to the way Clarence Thomas thinks about race and the court and how frustrating it is for him. Both that Thurgood Marshall was expressly tapped because he was African American, and that I think in Thomas's view that played so largely in his hearing. O'Connor just unbothered by it, right or wrong. She just thinks it is what it is, and I'm glad to have been the trailblazer. O'Connor quickly becomes a national icon. Even now, having retired from the court 6 years ago, she gets more fan mail than most of the other justices combined, particularly little girls who just think she walks on water. She really is, year after year and survey after survey, one of the most recognizable Supreme Court justices, even though she's not on the court anymore. People really treat her as a rock star. And that is something that she wears very graciously. I mean, she really has accepted the fact that she has this iconic role in American history. She was funny because the changes she made when she came to the Supreme Court were very O'Connor-esque. The most noteworthy change was, you probably know this bit of scuttlebutt, but there's a basketball court on the top floor of the U.S. Supreme Court, fondly known as the, quote, highest court in the land. And there's a, I know, there you go. I love that that still gets a laugh. I think even my kids don't laugh at that joke anymore. But okay, so the highest court in the land, and there's routinely been a fierce basketball game that is played amongst the justices and the clerks. O'Connor comes to the court. Say it with me now. She institutes the aerobics program, so that all the female clerks have to do like Jane Fonda aerobics and sneakers. And she introduces the lacy jabot to the court. She starts wearing this perplexing thing around her neck that just looks like a big doily. And she quickly, and this is interesting, and I'm sounding flip, but it's, I think, quite telling, develops this sort of den mother persona at the court. So she's the one who's constantly organizing outings. She's the one who's constantly got the clerks going to cool places and doing cool things. She's always having meals with them. There's just a really maternal figure at the court for the first time. And jurisprudentially, the other thing about O'Connor is she just sets off a firestorm in the legal academy, because suddenly there's a woman justice to look at. There's a woman's jurisprudence to look at. And the first really systemic effort to look at O'Connor's jurisprudence and to try to sort of winnow out from it a gendered jurisprudence comes in 1986. So O'Connor's only been on the bench for 5 years. And it comes from someone called Professor Susanna Sherry, who's at Vanderbilt University at the time. And she goes through 5 years of Sandra Day O'Connor's opinions to try to determine whether women judge differently than men. Now, you're all going to roll your eyes and say, A, 5 years isn't enough, and B, you can't, by what possible metric can you systemically study her opinions? But Susanna Sherry does, what is in 1986 the first major study of women's jurisprudence, and she comes out saying, and this is interesting, don't cringe, that Sandra Day O'Connor's jurisprudence is marked by relational, kindness, problem-solving jurisprudence. In other words, O'Connor is the polar opposite of Antonin Scalia. Scalia likes rules, O'Connor likes standards. Scalia likes hard and fast, crisp lines, O'Connor likes mushy, fuzzy solutions. O'Connor says Susanna Sherry is other-focused. She's not focused on herself. She's focused on solving other people's problems. And Sherry coins the term ethos of care to describe how O'Connor solves problems, that it's a real kind of caretaking, relational focus, not on creating law, but on solving the dispute that is right in front of her and making sure everybody's taken care of. So feminists in the room are probably cringing, right? This is typical 80s feminist talk about how women are foundationally different than men, and that men like to solve problems in a crisp and efficient manner, and women like to take care of everyone and make sure they feel good at the end of the day. And I just want to, in defense of Susanna Sherry, there's a path-breaking book that she relies on heavily in her research, and probably a lot of you have read it. It's by Carol Gilligan, and it's called In a Different Voice, and it's written in 1982, and this is really the book that, for feminist theory, and at that point for feminist legal theory even, creates this notion that men and women solve problems completely differently. And that when little boys solve problems, what they want to do is find justice. And when girls solve problems, they want to make everybody feel better and feel comfortable. And that girls are really socialized, this is according to Carol Gilligan, to get along, to be nice, to make everybody happy. It's not about rights. Men think about rights, women think about getting along. So very heavily influenced by Carol Gilligan, Susanna Sherry looks at Sandra Day O'Connor and says, hey, just like Carol Gilligan, right? Sandra Day O'Connor wants everyone to get along. And I will say, Susanna Sherry is right about some really important elements of Sandra Day O'Connor's jurisprudence. That a lot of Sandra Day O'Connor's jurisprudence, I mean, taking away the relational, mushy, right, not rights-based stuff, there is certainly a strain of O'Connor's jurisprudence that is very Carol Gilligan. And I'm thinking specifically about her religion jurisprudence, where, for instance, O'Connor very, very concerned about state-endorsed religion in public places. And O'Connor thinks about it and, in fact, ends up framing the test that is still the test today in terms of outsiders. How does the outsider feel when they see a creche or a church or a menorah in the town square? So very focused on that person who's left out. That's classic Carol Gilligan kind of getting alongness. But certainly it is the case of O'Connor that she's less interested, and even if you kind of pull out all the gender piece of it, O'Connor is not a rigid, boxed legal thinker. She is somebody who tries to solve problems and get out, and there is no sort of lingering O'Connor doctrine that explains Sandra Day O'Connor. So in that sense, I think Sherry is not entirely wrong. She's wrong to label it feminine, but she's not wrong to say that is in fact what O'Connor was doing. There are two principal criticisms that quickly emerge of Susanna Sherry's work. One is that this is ridiculously broad brush and just sort of mushy. You can't just read some of O'Connor's cases and say, oh, she wants people to feel good. The other is that it really starts to celebrate these qualities in women. We're relational, we care about feelings, we want people to get along, we're big problem solvers, that are not necessarily virtues in the political sphere. And do we really want to be, as feminists, embracing the idea that we're different and we want people to feel better, as opposed to, rigorous legal thinkers? Regardless of whether Susanna Sherry is right or not, O'Connor goes on to become the seminal justice on the Supreme Court. And for the first 8 years that I covered the court, it's O'Connor's court. And where she goes on almost every important jurisprudential doctrine, thus goes the court. So on abortion, it's her world. On religion, it's her world. On speech, it's her world. She really becomes, in this sort of piecemeal way, the defining voice of what was the Rehnquist court at that time for a long time. Now we get to Act 2, which I want to call different voices, as opposed to a different voice. In 1993, Ruth Bader Ginsburg is elevated to the court. And it's very clear immediately you're not going to be able to make sweeping judgments about women's jurisprudence anymore, because they don't agree on anything. O'Connor is, as a matter of conduct, having just told you that she planned a lot of field trips, crisped to the point of being terrifying on the bench. In every oral argument that I saw for all the years she was on the court, O'Connor was usually the first person to ask a question, and usually she asked it before counsel could finish saying, "May it please the cook," and there was O'Connor. Counsel, you know, very, very gruff, very brusque. Ginsburg couldn't be more opposite. Ginsburg is so soft-spoken, so gentle. Ginsburg, you know, at the beginning of oral argument, some of you have probably been to this, they swear in the Supreme Court bar. It's an incredibly boring ritual where a handful of lawyers are sworn in to be members of the U.S. Supreme Court bar. And trust me, if you've seen 3, you've seen enough. But a lot of these justices have seen hundreds, and they just, you know, gulp their drinks and talk to each other and flip through their notes. Ginsburg is universally, looks at every single one. She's kind of got this. As they're being sworn in, she's doing her little Jewish grandmother, Mazel tov. It's such a quintessentially Ginsburg thing. You know, she's just very, very, very gentle in that way. You know, O'Connor prides herself. In fact, her whole autobiography is that she's this up from the ranch cowgirl who didn't have working water on the ranch until she was 14. You know, she loves the autobiography wherein she prevails over hardship. Ginsburg really is acutely aware of difference and how women have struggled. O'Connor tells the story of graduating #2 in her class at Stanford and not getting a single job offer other than to be a legal secretary. And she tells it with, you know, some frustration. Ginsburg tells the story of the exact same thing that happened. She couldn't get a job. She couldn't get a clerkship. She was teaching at Rutgers and had to hide her pregnancy because they would have fired her for being pregnant. And she tells these stories with a real sense of women have fought hard to overcome these things. So O'Connor's much more inclined to say, I prevailed on the merits, every woman should prevail. Ginsburg is much more inclined to say, thank God that women banded together and that they don't face these hardships anymore. So really they couldn't be more different. O'Connor really disdains special treatment for groups in general. I thought a classic O'Connor moment was at the oral argument in Bush v. Gore, where someone was making the point that senior citizens in Florida were having a really tough time reading their ballots. And O'Connor, a senior citizen herself, burst out, "Oh, for heaven's sake, what's wrong with them?" You know, okay, clearly no special solicitude to the elderly. But, you know, O'Connor just doesn't have a soft, squishy core. Ginsburg, again, couldn't be more different. Ginsburg really, you know, see my earlier Mazel tovs, couldn't really be softer or squishier. But even though I think they're very, very different as people, what's interesting is having painted a picture of a very gruff, I want to say mannish, that's not the word, but certainly more masculine O'Connor as compared to a very, very gentle and soft-spoken Ginsburg, I now want to tell you that their jurisprudence is exactly the opposite. And that O'Connor's jurisprudence, to the extent that it's sort of relational and one-time only problem-solving, Ginsburg is Scalia. I mean, she is the liberal version of Scalia. She has a very, very clearly thought-out jurisprudential worldview that is epic in scope and that she applies in scope. And she really is, at core, a law professor. She's a very, very different character. And so I want to confound the categories I gave you earlier and say, if you're going to look for stereotypes and say that Ginsburg is more feminine and O'Connor is more masculine in terms of affect, could not be more flipped in terms of doctrine and jurisprudence. Okay. Now, when O'Connor steps down, I have learned the lesson, absolutely and fundamentally. O'Connor stepped down, I think my little one was about 2 weeks old. I was on maternity leave. I remember the New York Times asked me to write something about O'Connor, and I had him in the bouncy seat under me. I was swinging him, lactating, crying, you know, just couldn't have been more of a girl on maternity leave trying to write something rigorous and smart about O'Connor. And I remember thinking I had really internalized the lesson that 2 was enough at the court, that we had learned well the idea that there's no such thing as a woman's jurisprudence at the court, there's no such thing as a woman's temperament at the court, that these 2 women had proven that any attempt to say women are X is false. And that was great. And I actually was one of the first people out of the chute who wrote the story, we don't need another woman. You know, Bush should tap the best person for the job. It is clear to me, and I think clear to America, that this is not something that is gendered in any way. Now, a lot of people knew better, including Sandra Day O'Connor. And when she heard that John Roberts had been tapped, her response, literally, she was fly fishing at the time, as only O'Connor could be. She said, well, Roberts is good in every way except he's not a woman. Laura Bush actually made the same point almost immediately thereafter. And CNN polls taken at the time showed that 80% of America thought that a woman should be replaced with a woman at the court. I thought that was fascinating, that it was very, very clear to the American public that gender mattered much more than certainly I thought it did. 13% in that poll thought it was essential, that it was the defining thing that Bush should tap a woman. When Harriet Miers gets nominated for what then becomes the Sam Alito seat, and I won't say anything snarky, I will just say that Bush tested the proposition that any woman would make that 13%. I guess I did say something snarky. That any woman would make that 13% happy, and thankfully he lost. This brings us to era 3, which I want to call indifferent voices. This is not nearly as clever as it sounds, but and this is the time where it becomes manifestly clear that one woman at the court is not enough. So in the years that she was the only woman at the Supreme Court, Ruth Bader Ginsburg, I would submit, finds her voice for the first time. And someone who made her career and reputation on arguing gender cases at the U.S. Supreme Court really, really has kind of tamped down. With a few exceptions, she writes the Virginia Military Institute case. She certainly has exceptions where it's very clear there is a raging feminist inside Ruth Bader Ginsburg, but she's quite quiet about it until this era comes when she becomes the sole voice of women at the Supreme Court. And I want to suggest to you she changes quite profoundly, and I think her jurisprudence changes quite profoundly. So I've just finished saying that she is really one of the most soft-spoken and gentle jurists at the court. The Lilly Ledbetter case, which you may remember from a few years ago, and that's the equal pay case, Ginsburg pretty much goes insane on the bench, reading a dissent that is such a passionate defense of the proposition that women can't be expected to know that they are being paid less than their male colleagues, particularly when they're working somewhere where they will be fired for asking what their male colleagues are being paid. And she writes a really, I think, important and scathing dissent in that case. She writes another scathing dissent in Stenberg versus Carhart, which is the partial birth abortion case. Again, for the sort of feeling as though she bears the burden of speaking for all women. And so she does it. She speaks for all women in these dissents. And then, and I think I talked about this case last year at this event because I think it was really profound, the Savannah Redding case in 2009. And you may remember this case. This is a little girl who is strip searched for ibuprofen in her school because she's apparently leading some nefarious ibuprofen drug ring. This is an honor student, by the way, who has never had a problem. There's no evidence that she's ever been involved with drugs before, but this is a school with a zero-tolerance policy. Instead of calling her mother, which one usually does with a teenage girl, they simply strip search her, make her shake out her bra in front of school administrators. And she's saying it's a violation of her privacy. And we go into oral argument, and it was one of the most embarrassing moments for the U.S. Supreme Court that I have ever seen. I put it up there with Plessy in terms of just cluelessness about that it's not appropriate to make jokes about 13-year-old girls getting strip searched in school. And Justice Stephen Breyer, who I adore, but doesn't have that mechanism that leads him to count to 10 before he says things sometimes, starts joking that what's really all that different about a girl getting strip searched by school administrators. You know, I remember in gym class they used to pull up my shorts and laugh at me, and stunning. You know, this isn't gym class, it isn't shorts, this is a school who's humiliating a little girl. It's not funny. A lot of the justices are chuckling. And Ruth Ginsburg, again, if I've persuaded you of nothing else, doesn't get angry on the bench, looks over at Breyer and says, this isn't that. This isn't gym class. This isn't boys teasing other boys. This is administrators taking off a little girl's clothes. She was so angry that she then told Joan Biskupic, while the case was pending, and this is not something that she has ever done before, so the court has not decided this case. She says to Joan Biskupic in an interview in USA Today, you know what? The court needs more women. This is crazy. These guys, she had a sort of artful way of saying it. She said, they don't share my sensibilities. But, you know, it was her way of saying that to look at this case through the lens of, haha, you know, this is what guys do in gym class, is to fundamentally not understand what it is to be a 13-year-old girl. And we were stunned that she gave that interview. It was very not like her. I want to also point out that we walked out of oral argument in that case, and it really was gasp-worthy how trivial the male justices thought this search was. The people who wrote angrily about it were Nina Totenberg, Joan Biskupic, Dahlia Lithwick, and Linda Greenhouse. So I just want to, and which isn't to say yay women, it's simply to say thank God there are women covering the court now, because I thought that it was one of those things that might not have been flagged at all by mainstream journalism. So I walked out of that case, and it was very clear that case was going to come down 7-2 for the school board, that was a constitutional search. That's the question in the tenure of, and generally, you know, oral argument is a pretty good predictor of how it's going to come down. That case came out 8-1 in favor of Savannah Redding, Clarence Thomas dissenting. 8-1 saying the school, that's an impermissible search. And that was one of the very few times when I thought, this was Sandra Day O'Connor absolutely shaming her colleagues into thinking about this differently. Right or wrong, I don't want to put a value judgment on it. I don't know that it's the right thing to go to USA Today and say, oh my God, these guys are absolute Neanderthals. But right or wrong, I think that is clearly what happened in that case. I also think it's not an accident that that case comes down right around the same time that Obama is picking Sotomayor. Obama is really, I think, sensitive to the fact that one woman on the court is not enough. This brings us to Era 4, Act 4, what I call the rise and fall of judicial empathy. And this brings us to Sotomayor. So in 2009, President Obama, David Souter steps down, and Obama has his first chance to really explain his constitutional worldview to America. And what he says is really powerful. He says, I want a Supreme Court justice who embodies the quality of empathy. And you may remember the world went mad. They thought that empathy meant, I don't know, you're off your meds, you know, you're voting for certain people because of the color of their skin or their gender. In his view, in the view of his critics, empathy meant bias. Now I want to be very clear that whatever empathy means, it's not sympathy. Sympathy means I so over-identify with someone that I can't see straight. Empathy means, and Obama is really clear, I think if you go back and look at The Audacity of Hope, he describes the most important lesson Obama ever learned as a child was this lesson about empathy that his grandmother taught him. And what she said is, walk a mile in someone else's shoes. And he really, for him, that is empathy. It's taking yourself out of yourself and experiencing life through the eyes of someone who is unrecognizable to you. And I think that's what he was trying to describe, and maybe empathy wasn't the right word, or maybe that wasn't the right moment, because he gets thumped in the media, you may recall. Absolutely annihilated, on the left and the right, by the way, for wanting a Supreme Court justice who is biased, who more or less has a thumb on the scale for one team or the other. You know, that empathy by the end of this conversation is akin to some like derangement or mental illness that makes it impossible to judge fairly. And I think Obama did Sotomayor no favors, because he set her up by using the language of empathy for being that kind of Susanna Sherry parody of a girl judge, someone who is relational and has feelings. And he, I think, also set her up for a confirmation hearing that was going to be unpleasant anyway, but trust me, after 5 days of being there, was intensely and acutely unpleasant. I covered Kagan last year and Sotomayor 2 years ago, and I can't tell you how different they were. Kagan's was not a particularly sexist or racist or anything confirmation hearing. Sotomayor's was shockingly so. So this brings us to Wise Latina Gate. And I want to go back and just think about what Sotomayor said in her Berkeley speech in 2001. Please know she'd already been on the bench for many, many years. She was doing a literature review. She was looking at what all the studies said about whether women judges are different than men and how and whether it matters. And she said, in response, by the way, to Sandra Day O'Connor, who has very famously said, when asked this question, do women and men judge differently, O'Connor's quote has always been, a wise old man and a wise old woman will always arrive at the same conclusion. That's O'Connor's formulation of it, but there's no difference between how wise old men and wise old women think. Sotomayor, mangling, mashing, looking at all the data and all the studies, and thinking about her own experience on the court says, and here's where I quote it for you correctly, I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male who hasn't lived that life.
Wow, I remember that.
Yeah, so there it is. That's what she said. Now I just want to, as a journalist, point out all the hedging words, right? I would hope, with the richness of her experience, would more often than not. You know, this is not an unequivocal statement. This is about as equivocal as you can be. But I think she was saying that in some subset of cases, I would hope that a wise Latina would come to a better result than a white man who didn't live that life. I also want to point out that at his confirmation hearings, Sam Alito said very similar things. At his confirmation hearings, Clarence Thomas said very, very similar things. But something about either that formulation or that person sent America into a frenzy. And we watched, 5 days of hearings in which she was systematically accused of being biased because of that statement alone. Trust me, one day would have been enough. It was really endless. So I just want to go through what the data shows and think about it with you. A meta-study that was done in 2008 looked at 30, and I want to bracket what I'm saying by telling you one more time. The data is not great. The social science data on this is just not terrific. It's very, very hard to control for the other factors. A much better predictor of how a person judges than gender is ideology, just for instance. So how do you control for that? You can't. Meta-study conducted in 2008 looked at 30 other studies and looked at the relationship between gender and judging. And of those 30 studies, about a third found that there was an enormous difference between the way men and women judge. About a third found that there was, in fact, no difference at all between the way men and women judge. And about a third find, and this is the interesting part, that there's a difference between the way men and women judge when women are on a panel with men. When women are on a 3-judge appeals court panel, that happens in the federal appeals court very, very often, when you're on a 3-judge panel, that's where the action is. That's where it's interesting. And so I want to tell you about a 2008 study, which is my favorite study, because I think this is where we should be thinking about these things. This is a 2008 study from Northwest University called Understanding the Causal Effects of Sex on Judging. Christina Boyd, Andrew Martin, Lee Epstein, in case you're taking notes. And they look at a whole bunch of sex discrimination cases that appear before 3-judge panels in the federal appeals courts between 1995 and 2002. They look at every sex discrimination case. So one thing we know is that it's very, very hard to find any patterns in non-gender related cases. In your average, slip and fall case, we don't see a lot of patterns. We see interesting patterns, though, in cases that have to do with abortion waivers or gender discrimination. So they look at they decide to control for that by looking only at gender discrimination cases. And they find that male judges are 10% more likely to rule against a woman alleging sex discrimination than women. That's the first thing they find. So male judges are more inclined, 10% more inclined to rule with the discriminator, the alleged discriminator, as opposed to the woman. Okay. But, and here's where it's fantastic, if there's a female judge on the panel with them, then the number shifts from 12 to 16%. If there's a female judge on the panel, then they start to rule for the women much more of the time. And this study has now been borne out by several studies that show that the fascinating thing that happens is that men who are on panels with other men tend to be quite unsympathetic to women plaintiffs. Men who are on the panels with even one woman start to conform their views to the views of the woman judge on the panel. Now, the suggestion here is that feminism is contagious, which is really quite stunning. And again, I want to be really careful by saying I'm trying to be descriptive and not normative here. I don't want to be standing here saying that this means that there should be a woman on every panel in the country. This is a very fraught conversation, which is why Sonia Sotomayor almost didn't get confirmed. But I just want to make the point that the one thing the studies seem to show isn't that women have different brains than men. It's that when a woman is on a panel with two other men, she's able to say, stop. Here's what I think, and then she gives them a speech that I imagine sounds a lot like the one Ruth Bader Ginsburg gave her brethren after the Redding case. You don't get it. And they change their views, and that is fascinating. So I want to just tell you right now, I think this is hardly surprising. This is something that's been going on at the court that transcends gender, and it's been going on for a long time. This is what Byron White says of Thurgood Marshall. Thurgood Marshall, quote, would tell us things that we knew but we would rather forget. And he told us so much that we did not know, due to the limitations of our own experiences. So this is Byron White simply saying, having Thurgood Marshall sitting at conference changes the way we think about everything. Because it's Thurgood Marshall, and he's sitting here saying, here's what it's like to grow up in the Jim Crow South. You don't know this because you didn't grow up there. Sandra Day O'Connor makes this exact point in her book, The Majesty of the Law. She says that Marshall was a great, quote, raconteur, and that he would push his colleagues constantly to see the world differently from the way they saw it. Linda Greenhouse has a word for this. She says, Thurgood Marshall was a master at telling people that they don't know what they don't know until someone tells them what they don't know. And it seems to me that this is the same quality we're seeing on these three-judge panels, where it's not that a woman is saying, I'm relational, I want to solve the problem, I want everyone to get along. It's not Carol Gilligan. What it is the ability to turn to two men on the panel and say, here's something you don't know about gender discrimination. Here's an experience you haven't had. Here is me, Ruth Bader Ginsburg, explaining why you're not going to get an embossed letter from your employer in Lilly Ledbetter's case saying, we're discriminating against you. There's no way to find out. And that Sam Alito's thesis that Lilly Ledbetter should have somehow just known that she was being subject to discrimination was absolutely not borne out by real life facts. So I want to bring you up, and I know I've talked a lot, but I want to bring you to Era 5, which I like to call the roller derby, where we have three women at the court, and it is awesome. And that is a normative statement. It's just objectively awesome, and I defy anyone to say otherwise. So I'm going to just cite to one other really interesting study that you can put into the mix here, and that is this 2000 study that has nothing to do with women's brains. It's a Wellesley Center for Women's Study, and they determine, I think this is interesting, that 3 is the magic number on corporate boards. When you seat a third woman on a corporate board, everything changes because they all start to talk. There's no longer that sense that both O'Connor and Ginsburg have described of being incredibly careful when you speak at conference because you're the only woman in the room and you're speaking for all women. Suddenly you're not, because there's 3 of you. And so corporate boards invariably experience a very, very profound shift when there are 3 women seated on the board. This is absolutely, Ginsburg's claim when Kagan comes on the court is, for the first time, we're not curiosities. We're not, this isn't a petting zoo where you go, look at the girl in the lacy jabot. Yeah. They're justices now. And this is, to not be a curiosity, I think, is something that Ginsburg had waited for her entire life. So how are you, how is this playing out at oral argument? Again, I want to be really clear. These 3 women are so different. And what they show me is that there is no such thing as a woman's voice at the Supreme Court. They could not be more different. But what they are is part of the mix now. You have Ruth Bader Ginsburg still on her second round of cancer, feisty as ever, writing some of the best dissents of her career this year. You have Sotomayor, who's really found a strong, strong voice for herself in some of the criminal and civil liberties cases. Kagan, who is, I have to tell you, a mystery still because she's had to recuse herself from almost half the cases the court has heard this year because she was the Solicitor General last year. She set a very, very high bar for her recusal. And so any case that her fingerprints are on, she has not heard. It's been hugely problematic in terms of having 4-4 cases that don't stand for any legal proposition, but also problematic for those of us who are trying to figure out what makes her tick because she's not there a lot. I will say that her writing is incredibly powerful, and the one thing we're seeing about Kagan early days, is a real flair for writing. She's got Scalia's ability to sound like a blogger, even in her own opinions, and she's very, very, very funny and deft at oral argument. The other thing I'll say, just as a bracket about Kagan, is that I was the guy who was on Rachel Maddow last year saying when they tapped Kagan, oh, come on, she's not going to be Bill Brennan. Nobody's Bill Brennan. She's not going to have this Svengali-like ability to get everybody to conform to her views. She kind of is. She's really very, very good at oral argument, at picking off that fifth vote that she needs. I think that Kagan's gift, and it was something that I made light of when he first tapped her, is an ability to really listen to people on a court full of kind of crazy narcissists. She's incredibly outward-facing, and it's been really interesting to watch how skillfully she is able to kind of control the other justices on the bench in oral argument. So I think stay tuned. She's got a long career ahead of her, and I don't think we can say anything about her jurisprudence yet, but I do think that she's quite different from anyone we've seen at the court before.
Why was she gone?
Because she was the Solicitor General last year, so that's the president's lawyer. So in any case where the president filed a brief, she's recused herself. She doesn't hear them because it's a conflict of interest. So one last thought on this, and this is going to sound like a punchline. I don't mean for it to be. But one other lesson of this year, I was telling John before I started that every speech I've given this year, the first question, I'm just going to preempt it now. The first question is, what was Ginny Thomas thinking when she called Anita Hill at 7 in the morning this fall? And I don't know the answer to that. I'm not a neurobiologist. But I will say absolutely seriously that I think part of making space for women and their voices at the court is going to be rethinking spouses at the court. And that I find some of the criticism of Ginny Thomas and Clarence Thomas to be quite unfair. And I would just cite for you the fantastic new Brennan biography that came out this year by Steve Wormiel and Seth Stern. Felix Frankfurter's wife was so depressed that she was literally confined to, an attic room. Marjorie Brennan was so depressed she drank herself to death. Being a Supreme Court justice's wife in an era where you could have no voice, you couldn't speak, you couldn't complain, you couldn't give press conferences, you couldn't have any political opinions, was hell on those women. And so I think we really need to be a little bit more generous as we enter an era where justices are married to these fantastic, interested, active women. Now, I'm not saying there should be no ethical rules, but I'm saying that it cannot be the case that we leave those women to drink themselves to death on the third floor. We have to make space for spousal voices too. And I just want to kind of close by saying, if you've taken nothing from what I've said here, I think I am quickly rounding my way to the view that there is no such thing as women's voices at the court. I don't think that the court has any one monolithic women's voice in any more than the world has any more one monolithic voice. I think the great gift of having 3 women at the court is that we now have a laboratory in which we can see there is not one woman's monolithic voice at the court. So I don't think it's so interesting to think about the changes to the way the court looks. I think the really valuable question going forward is going to be, how does the court look at us now that there are women on the court? And I think that's that's the right direction to be thinking about. So thank you very much for your time. I'm very happy to take questions. But I know I didn't do my speech stuff, so if you want to talk about free speech, we can do that too. But thank you.
Okay. There isn't a woman's voice, but there needs to be a diversity.
Yes.
I mean, that is what you're saying, is you need diversity.
Right. And that no one
we have
woman.
not had that with our white male courts.
Well, I think diversity means a lot of interesting things. I think you have a problem when you only have 9 seats. And the federal bench, the appeals courts and the district courts are shockingly not diverse. So you're quite right. This is a systemic problem that isn't limited to the Supreme Court. You get into trouble when you're looking at 9 slots and everybody wants a representative of their team. So, when there is a vacancy at the court, what I get inundated with is emails from groups saying, when are we going to appoint the first blind justice? When are we going to appoint the first Asian justice? There's an enormous amount of pressure on Obama to appoint the first Asian justice to the court because it's not representative of this country. I think that there's a more interesting question about diversity at the court, and that is not just the color of your skin or whether you have an ovary, it's job experience. And we happen to have a court in which every single member has come off the federal bench. We have almost no one on the court who has any kind of experience like O'Connor, where she was in fact a state litigator. We have no one on the court who is a death penalty litigator. We have no one on the court, who has done crucial kinds of work that the court sees every day, but there's not that voice saying, you don't know what you're talking about. So I think the real problem at the court, and this is going to become a bigger and bigger and bigger problem. We saw it with the Goodwin-Liu nomination. This is Obama's pick for the Ninth Circuit, who was scuttled a few weeks ago. And I will disclose that he's a friend, and so I obviously have a dog in that fight. But Goodwin, one of the reasons he's scuttled is because as an academic had done an enormous amount of writing. And anyone who does an enormous amount of legal writing will no longer get confirmed to the court. So we have a confirmation process that is winnowing out anyone interesting, anyone controversial, anyone who's had a job that someone could object to, and we are quickly getting to the point where if you were not hydroponically raised from birth to be a Supreme Court justice, and I would submit that that is Elena Kagan, that is John Roberts. I mean, these are people who have never misstepped in their lives, and they knew they wanted to be on the court and have lived their lives accordingly. I don't think it's good for the country. That's the diversity that I worry about. So I think, and I don't want to accuse them of being sort of soulless careerists. I think they're better than that. But I do think we are creating a process whereby nobody interesting will ever get confirmed again. Mm-hmm.
How responsive do you think the American people or the Congress would be to expanding the number of justices or to ending a lifetime term limit to increase diversity in the court?
It's a great question. I mean, one of the funny things about FDR's court packing plan was that it was that, right? It was going to be add new justiceships. And you would think from the outcry that it said somewhere in the Constitution that there are only 9 justices. People went insane. Nowhere in the Constitution does it say there are only 9 justices. There have been 4 justices, there have been 8, there have been 12. The number was never fixed until quite recently, which is, I think, why FDR thought he could get away with it, because there's nothing magical about the number. It turns out there is something magical. People went insane, and FDR, who couldn't have been more popular when he proposed this, almost scuttles his entire presidency over it. So I think that Americans, and I've said this here before, and someone always gets mad, but I think that the court is the secular church in this country, and the Constitution is the secular Bible. And Americans have really, you see it now more than ever with the conversations about the Constitution that we're having, but I think we have fetishized the idea that 9 is magic and inviolate. And I think in terms of, I'm actually one of the few court watchers who has a problem with term limits. And that's partly because I have just a mind-blowing, brain-melting crush on John Paul Stevens. And I think, he is absolutely living evidence that you can be on the court for 30-some years and never miss a step. And so I just really, I don't know that I approve of the idea that at some magical line we yank you off the court, because often that's when you're at your very best. I will say that the framers did not envision, when they created the federal judiciary, that people would live to be 100 and that people would be tapped for the court at the age of 42 and possibly sit on the court for 60 years. I mean, that was never the plan. So clearly we have gone horribly off the rails, but I think the American public is very, very concerned that any attempt to mess with either the number of the courts, the number of the justices, or how the justices function amongst themselves is going to be ill met. I will say that the proof that I'm wrong is what's going on with judicial elections in this country, where states that elect their judges have become more and more rancorous and certainly more and more expensive. And you may know about the Iowa Supreme Court election, where 3 justices were just bounced in a retention election for 1 vote. So Americans love the idea of controlling the judiciary. States that have judicial elections will not give them up. So I think that there are 2 very different strands at work here. I think we have a sort of fetishization of certainly the Supreme Court, and then I think at many other levels we have a feeling that the judiciary is out of control and we want to control them. And I think the state elections are a really good example of that. So I don't know how responsive that was, but yeah.
I want to go back to your diversity a little bit. There was at least discussions in the last few years about the fact that the training of all the justices is very narrow, given the wide range. Do you think that that is an issue that anyone needs to be concerned about, in relation to all the other areas that people can be concerned about?
No, I think that's right. I mean, I think that every single justice on the current Supreme Court went to Harvard or Yale. Every single justice on the current Supreme Court, if they had a job at all, was a professor at Harvard or Yale. You know, they all of them, some of them were briefly prosecutors, some of them worked, almost everyone that has been appointed in the last couple of years by a Republican president worked in a executive branch office. So they've had 3 really narrow pipelines, and I think that it leads you to view the world in a certain way. And I would just go back to O'Connor and say a lot of those qualities that Susanna Sherry picked out, the problem solving, the bring everyone to a table, try to find a Pareto optimal solution problem thing, that's not a gender thing as much as it is a state legislator thing. I think that somebody who's worked in the Arizona state legislature gets really good at dropping ideology to solve problems. And the fact that there is not one person with elected political experience on the court, I think, goes to how completely polarized the court is. John Roberts gave a speech last year where he said he loves that the court is as rarefied as it is, that he thinks it's great that there are no, Hugo Blacks or, Robert Jacksons, all these crazy cowboys who used to be on the court, who had all these histories and all these agendas and all this stuff. And they'd go give speeches and, they'd run the Nuremberg trials and they'd come back and they were KKK members. It was insane. And Robert sort of likes how pristine it is now. He says it's a very academic court, to which my response, and I think yours, is, that can't be right. I mean, that's great in its fashion. It's good to have 3 of those people, but to have 9 of them is really problematic. And so I do think that, having lost the ability, I think both presidents on both sides, to tap anyone other than someone who's been on the federal bench for 15 years, is to lose the ability to know what most Americans really think. I'll tell you just one more story since I'm telling stories, and it's a Friday. My favorite oral argument, I think, ever, I mean, the time when there were tears pouring down my face because it was so funny, was a privacy case. John will remember this, but a privacy case where they were searching passengers on Greyhound buses. They were searching their bags at the border. And the question was whether your average passenger on your average Greyhound bus has a reasonable expectation of privacy in his backpack that's above him on the rack there. And watching the justices ask questions about it, I just wanted to be like, objection. Has any of you once been on a Greyhound bus? I don't think you get to talk about that. You have this sense that if you had loosed David Souter in in Washington and said, go find the Greyhound station, he would have just walked in circles for 14 years. I mean, and again, you know, I don't want to, you know, besmirch how brilliant they are, but I think that the fact is, you know, we had the same thing with the pager case last term, where the justices were trying to determine whether you had a reasonable expectation of privacy in your police-issued pager. And the justices were just poleaxed. Pager? Does it talk to a signal on a satellite? And, you know, and you just had this sense. Some of these are technological questions. Some of them are just these people don't live in the world. And so I think, you know, I would commend to you a decision that came down yesterday about Mirandizing children. But it was a really interesting moment where I thought Sotomayor, and it's why empathy is on my mind right now, but Sotomayor sort of really understood what it's like to take a 13-year-old child, lock him in a conference room with some cops, and question him without telling him what his Miranda rights are. And I think it showed a really acute sensitivity to the fact that children are in fact different than adults. Sam Alito wrote this dissent that was really perplexing about how could a judge begin to know what it's like to be 13. It just made me think maybe Alito went from 12 to 14. But it was just a strange, you know, and it goes back to this empathy question. If you are going to decide cases about 13-year-olds being Mirandized, it helps a lot to be able to think like a 13-year-old in a custodial interrogation. And I think, you know, I'm not saying that all 9 members of the court should have been routinely custodially interrogated for larceny when they were 13, but I am saying that I think the bandwidth of experience is shockingly, shockingly narrow. Go ahead.
Yes, I was really interested by your description of how Ginsburg...
Can't understand what he's saying.
Sorry.
Can you go one louder?
Yes, I was really interested by your description of how Ruth Bader Ginsburg went to bat for Savannah Redding, and you used the term that she shamed the male justices into understanding the trauma that this girl went through. And honestly, to me, that sounds like she turned them on to their own misogyny and made them realize that they were being very narrow, good old boys. And I'm wondering, how do you keep that from morphing into political correctness, and how do you keep that on the track of actually engaging their perspective?
Mm-hmm. I think it's a great question. I mean, you know, when she did it, when she gave that interview to Joan Biskupic saying, you know, these guys don't understand and there needs to be more women on the court, I was not thrilled, because it seemed like it was extracurricular talking, and it seemed like it was shaming, and it seemed like I've always found, certainly at law school, but even later in life, that conversations that begin with "you don't get it" never go very well. That we need to do better than calling each other out for our myopia, and so I think you're onto something. I do think that, you know, what Ginsburg did, and I don't know how that conference went. You know, when there are 9 of them in the room and they close the door and clerks are not in and we don't have any idea what happens in conference until 30 years after some justice dies and we get their papers. I mean, we will not know what happened at the Reading conference until my grandchildren are covering the court. Poor children. But I think that the appropriate place to do what she did publicly was probably in that conference. More akin to what O'Connor says Thurgood Marshall would do at conference, which is say, you know, you missed something. I think calling them out publicly, I don't know what the word politically correct means, and I think it's a sort of code for a lot of things that I think it's just a sort of sloppy nomenclature. But I will say that I think tactically she made a lot of people very, very angry by calling them out publicly and saying they didn't get it. And I think one of the things that's sort of surprising is that it was Ginsburg doing it, because she's not usually that way. To me, it's a testament to how upset she was, that this crossed some line for her, where she literally felt that she had to give an interview to the largest, you know, circulating newspaper in the country and say, officially we now need women on the court. But I don't disagree. I think tactically it does kick a lot of dirt into the machine, and it does send the message that these extracurricular conversations between justices, you know, that happen through the media are of some value. And I have some real questions about that. There's an amazingly good book that has just come out that talks about the way the court uses the press to talk to one another. And it's just a really fascinating, and I think this is a very good example of Ginsburg feeling that she couldn't accomplish in conference something nearly as extravagant as she needed to say. But I quite agree with the premise that I think that it raises more questions than it answers. Go ahead.
You were talking before about labels and the difference between the three female justices ideologically. And you know, usually they're on one side and Alito and Thomas and Roberts are on another. Do you foresee a conservative woman? You know, you probably would require a Republican president in order to nominate her. But is there anybody like that that's on the scene?
Yeah, there are some fantastic women on the appeals court, some fantastic women on the state Supreme Courts. When we were looking at Bush's shortlist of people to replace Rehnquist when he died, it was a lot of them were very, very, very high octane women who were federal judges. I think one of the reasons Harriet Miers was such a surprise was that it was as though he plucked her out of, you know, his White House counsel's office and leapfrogged her over many, many fantastic candidates. The other thing I think I would say is that by most measures, O'Connor was probably a conservative woman judge. I mean, by almost every metric you would use, she was certainly a centrist, certainly a moderate. I don't think anyone, including O'Connor, would say that O'Connor was a liberal. So I think the three women who are on the court now are far to the left of her. But I think O'Connor, one of the reasons that, you know, I mentioned that her thumbprint is so on so many kind of different doctrinal areas, was that she was smack in the middle of a 4-4 court. But I think she was, and still is, on many, many issues, very conservative. So I think, yes, there are really impressive conservative women judges in the pipeline. I think there are conservative women academics, if we can ever pick another academic. I think one of the, you know, when I started, I said, oh, these little girls used to write letters to O'Connor. You know, when I was at law school, she went to Stanford and I went to Stanford. And when she spoke there, it was like a rock concert. I mean, we just mobbed her. And it made me realize, I know this is 1991, it made me realize there's an entire generation of women who might not have gone to law school but for Sandra Day O'Connor. So I really think she has shaped the sort of sense that women have that there's a place for them at the court, more than almost anyone. And I will also just say, I know there's more questions, but I will say that one of the things that I thought was really fundamentally life-changing from covering the Sotomayor hearings was that even while the senators were lambasting her for being a wise Latina and a bigot and a racist and a man-hater and all the rest of it, if you turned and looked at the back of the chamber, the Senate chamber, it was rows and rows of 14-year-old Hispanic girls who stood in line, often for hours, to get in there and watch this. For them, this wasn't, you know, some political kabuki. This was a framing moment that affirmed that they could someday be on the court too. And so for whatever you think about these issues, and I agree, it's really hard to talk about them without sliding into generalizations and coded language. But I think to look at the back of that room and see an entire, you know, generation of young Latina women who saw a place for themselves at the table, for me, that was incredibly powerful. Did you?
Yeah. I wanted to know, what do you see as the future for choice with this court?
So the question is, what's the future for choice with this court? I think that this court doesn't want to touch the issue. I don't think they need to touch the issue. I think where it's happening is the states. And, you know, you've probably seen the data about the number of states that have passed measures just since November. And some of these are measures that are clearly unconstitutional. I mean, they violate not just Roe and Casey, but Stenberg. So I think these are efforts to force the issue up to the courts. But I think that this is a question that the court is quite happy to leave to the states. The states are going to eviscerate the substance of Roe, and the court doesn't need to touch it. So it's not, none of it is promising for the future of choice, but I think to look at the Supreme Court as the final arbiter here, I think that in states like Nebraska where you functionally can't get an abortion anymore, it doesn't matter what the court says. Yeah.
You were talking about the reverence that the public has for Justice O'Connor. What do you think is going to happen with a lot of her squishier decisions? like Grutter, like, oh, this only lasts for so many years, or, I mean, any of her others.
Marty Lederman is a blogger who was at Balkanization for a long time now. He went to work at the Office of Legal Counsel now. I think he's blogging for SCOTUS blog. And I remember when O'Connor stepped down, he made a list of basically like a target sign list of all of her big cases that were going to be annihilated in the next 10 years. And I think he's been pretty much, I mean, you know, most of her signature jurisprudence has been already winnowed away. You know, most famously, Citizens United, right? That she was the fifth vote on campaign finance. So I think, you know, one of the sort of great paradoxes of O'Connor is that while she was on the court, she was the most powerful jurist in America, and as soon as she left, that legacy was dismantled really quickly. She gave a speech last year at William and Mary where she pretty much out and out said, I can't remember the exact language, but that it's quite painful to watch all your work dismantled so quickly. So I think that she was an accident of history in that she was in that right, she was the fulcrum at that court at the right time, but it was invariable that there's going to be no one who looks at the world the way O'Connor did, and I think that's happened. I think she'd be shocked at how quickly it happened, but I think you're quite right that it's happened. I can take like 3 more. Go ahead.
Dahlia, this is so fascinating. And I keep thinking about the impact of women on the court and how that is working on the rest of the court. And I'm thinking that kind of psychologically there's an impact when you have a closer connection in the moment, proximity, with someone of a particular view or a particular kind of, you know, gender, that you start to develop a connection and empathy just by that proximity. So that I just wonder what you think about that may be part of what's going on, that actually the other justices are kind of broadening their view because they have someone else there that they can experience their experience. It's like they're getting empathy.
I think that's exactly right, and that goes to your point, which is that's why we need such a vastly more diverse bandwidth, because it, you know, to be like, oh, I empathize with you, I only went to Harvard and you went to Yale, like that can't be, you know, the totality of the spectrum. But I do think, you know, Scalia has even said there were things people stopped saying when Thurgood Marshall was in the room. And so it sort of flicks at the question about political correctness, right? Is that people self-censoring because Thurgood Marshall is in the room? Or is that people, because Thurgood Marshall is in the room, saying, oh my God, there is a whole world of experience that I know nothing about? And I think you're right. I think it's the latter. I don't think it's the self-censoring or the feeling that you can no longer say things. I mean, there were people on the court who literally went their whole lives refusing to speak to the Jewish justices, like wouldn't speak to them. So you know, the court comes from a long history of really fractious conduct, and whatever you say about this court, I absolutely believe it is true. This is a very collegial court. This is a deeply respectful court. You can't believe it because you read the way they write to each other and you're like, oh my God, do they just go home and throw darts at, you know, the photo? But this happens to be a moment in history. If you look back at, you know, Felix Frankfurter trying to get Robert Jackson thrown off the court. I mean, they hated each other. This is not that court. And so I do think that it is a court that has worked its way toward a much greater capacity to hear different views and to not demonize based on race or gender or religion the way they used to. That said, I think because it's not a very diverse court, in a lot of ways that count, that's an easier enterprise. So it seems to me that you can say it's not a fractious court because the court has evolved to the point that they're more respectful of each other, or you can say it's not a fractious court because they all are kind of the same person. I think it's complicated, but I do agree with the premise that this happens to be a court that is incredibly good at listening to one another. Chief Justice Rehnquist was famous for when he started conference, when he took over from Warren Burger. Warren Burger used to let conference ramble, and everyone would be like, oh, and I'm going to read you my grocery list, and then I'll do a little interpretive dance, and, made the justices crazy. And so when Rehnquist took over, he decided conference was going to go fast. We're just going to go boom, boom, boom. Everyone's going to say how they're going to vote, and we're going to move it along. Roberts has really, I think, done a lot to change that. Roberts really, I think, understands that it's incredibly important for people to be heard. And conference has, under him, I think, become a much more useful proposition where people are, in fact, listening to each other. So I think that there is something to be said for what's happening isn't just cosmetic, pretending to listen to each other. I think that there is a deep acceptance and regard for each other. And I always say this at speeches, I forgot to say it. Is in addition to my highest court on the land joke, the great surprise about the current Supreme Court that people don't know is that the two closest friends on the court, by far, are Ginsburg and Scalia, who have a deep, deep, deep friendship that transcends their absolutely, opposite political. So I really think this is a different court. I can take, I think, one more question. Yeah. How about you? Okay.
I'm just wondering, you mentioned the fact that the court is now very pristine. It's people who have been brought up to be on the court. Do you think that that's a flaw with the Senate confirmation process? Mm-hmm.
Because I think that, the joke of the Bork hearing is that it was a teachable constitutional moment for everyone in America, and the lesson the teachable moment gave us is don't be Bork. Never say what you think about anything, and more profoundly, never think about anything. And after the Bork hearing, which really was, you all know this, that the person who wrote the most praiseful and laudatory thing about the Bork hearing and how it was exactly the template for how hearings should be was Elena Kagan. And Kagan wrote this law review article where she said that was a moment in which he expanded on his constitutional views and they asked good questions and we had a conversation. That's what they should all be, says Elena Kagan, who then goes on to have 4 days of not answering any questions. So, everybody thinks that was a sort of high water mark for what the process could allow, but after that high water mark, the process would never allow it again. And so now you have these ridiculous, ridiculous hearings in which nobody can be nominated if they've done or said anything controversial. If they've done or said something which I think is fairly uncontroversial, like the wise Latina, we focus on it like dogs with a bone for 5 days at the exclusion of an 18-year judicial career that we forgot to talk about in Sotomayor's case. And I think that people who have ever done or said or written anything interesting are both unconfirmable and more inclined to take themselves out of the game. And you're seeing now people who are in all sorts of confirmation settings taking themselves out of the game, because why would you do that to your family? So I really do think this is a one-way ratchet. I see no way that they're getting better, and I think it's contributing to nominees who are, I guarantee you that my young friends who are academics and you all who become academics are going to be thinking somewhere in the back of your head, do I want to write this scathing piece about, presidential war powers when I can write a piece about, the jurisprudence of the Nike sneaker? Because one of them is going to keep me from getting on the bench, and we're going to see, I fear, a lot of jurisprudence of Nike sneakers. Last question.
Do you have time to talk about the speech case?
I do. I will go quick. I've got to get a plane, which is why I'm. So this was the term of free speech at the court. To the extent that we had any barnstorming cases, it was Snyder v. Phelps, which was a very strange case, and nobody knows to this day why the court took it, because I think the Fourth Circuit, which affirmed that you can, in fact, be horrible, odious, despicable human beings and still have free speech rights, got it right at the Fourth Circuit. But the court took it. I think, you know, the other big case that's going to come down that the court heard in November, which we still haven't got a result in, and it's perplexing that it's taken this long, is the violent video games case, the Schwarzenegger case out of California. This is a ban on video games for children under 18. Again, it seems like an easy case. This seems like protected speech. The court has never said an entire class of speech, you know, is off the table. The violent video game oral argument was my favorite of the term, only because there was an amazing moment where Justice Alito and Justice Scalia are mixing it up over violent video games. Scalia thinks, of course this is protected free speech. You know, my God, the framers used to go to hangings. You know, they took their kids to hangings. How could this be worse? And, you know, here's Alito, who's become really the voice at the court of civility and you know, creating boundaries for First Amendment rights. And Scalia is going on about the framers, and Alito looks over and says, Alito is many things, but funny he is not. And he looks over and says, Justice Scalia wants to know what the framers would have thought of Mortal Kombat. You know, the House just, you know, everybody cracks up because it's really funny. And it's also super funny coming from another originalist, right? Like the idea that there are limits to originalist stuff. So I think it looks to me as though, based on that argument, that the court's going to come out sort of like it came out on Phelps on violent video games, which is they will say you can't go and outlaw a whole class of speech. For kids, I think the reason it's taking a very, very inexplicably long time for the court to come out with an opinion is that Alito is writing a dissent that's going to look a lot like the Phelps dissent. So the quick thing I'll say about speech, and I think we talked about this last year when I was here, but I think the really interesting speech thing that's happening at the court is that there is this split between Alito and Scalia on these speech cases. So these are two originalist conservatives, right, who are Reagan, Mies, strict constructionists, and they are absolutely, could not be more different on the speech cases. And this starts last spring with Doe v. Reed, and I think I talked about that when I was here last year. This is a really interesting Washington State case where in order to get something on the ballot, a ballot initiative, you have to sign something, right, in the parking lot at Walmart that says, I think the state should have a referendum on X. So the state of Washington is having a referendum on their all but gay marriage, to repeal their all but gay marriage law. And the Sunshine Laws, the state's transparency laws, say all those names of everybody who signed the ballot initiative goes up on the web. This is public information. So the case comes to the court as a First Amendment challenge. Do I have a privacy interest in protecting my name? I have a right to not have people know that I signed a ballot initiative. It's an amazing case. It sounds really jargony, but it leads Scalia to say at oral argument and then to write, civic courage requires that people know that if you are legislating, if you are performing an act of legislating, people should know it. And he goes so far as to say, we didn't have a secret ballot in this country. For the longest time in America, you walked in and you said, I vote for Joe. And if people wanted to torch your house, they did. Like, and, you know, this is vintage Scalia, right? And then we have Alito, on the other hand, who, you know, remember, for Alito's first couple of years on the bench, people were calling him Scalito. They were supposed to be sharing a brain. And Alito comes out completely opposite, saying, you know, you have a right to privacy in your name. People's names go up on the internet, then you get Google Maps, and you get Google Earth, and you find their house, and then you know, go to their kids' kindergarten. And so there is this amazing split between the two of them that was really, I think, ratcheted up 2 levels at the violent video game case, where Scalia is, of course this is protected speech, and Alito is, this isn't even speech, this is filth. You know, this is people in video games ripping the heads off girls and tying them to train, you know, it's disgusting. And we have it again in the dogfight case last year, so there's a really amazing free speech case where the court 8-1 says that Congress had tried to make it a crime to disseminate videos depicting animal cruelty. It was very, very broadly written. The court strikes it down. This is protected speech. Scalia again, my God, bullfights! You know, this is great speech. And Alito writes this searing dissent saying, this isn't speech, this is people pitting dogs against each other until they bleed and die. So I think watch for this disparity at the court, because I think it's really interesting. And the last thing I'll say about it is I think it has a lot to do with, forgive me, their confirmation hearings. I think that the reason that the two strongest voices at the Supreme Court for privacy, keeping names off the internet, keeping cameras out of courts, think about the court unplugging the Prop 8 case last year where it was supposed to be videotaped. This is the California gay marriage case. The last minute the court rolls in with a per curiam opinion that says, can't show that, can't have a video of that. And the people who are feeling most strongly about this are the people who had the worst confirmation hearings. This is Clarence Thomas and Alito, saying if you roll cameras and you make people's names and information public, their life is over. And I don't think it's an accident. Too soon to tell. I started by saying you can't tell from a sampling of 4. You can't tell from a sampling of 4 cases, but I think if you want to watch a really interesting fight emerge, I think Scalia and Alito, and put Thomas, and I would put Breyer in with Alito on these speech and civility cases. I think the court, what we think of as speech doctrine is about to change. Thank you very, very much.